In this, fellows, your lordship has covered item.
Is also not maintainable.
Yeah,
Correct.
I'm just coming to why the appeal is not maintainable. Well, this is challenged on 12th of August 24. Lordship has got that? Your lordship has just dealt with the single judge, which is the earlier order. This is challenged. The division bench on 12th of August does actually nothing except saying remand it, which is wrong, of course, because you, the learned single judge, decide maintainability of my enforcement and interim application. I hope I'm clear, Manas.
The learned division bench demanded the matter to the single judge to decide whether the interim application filed by the petitioner were maintainable, whether enforcement petition was filed prematurely. All that.
I'm grateful. Now,
and then upon remand, there's an order of the 3rd of September by the
Now, this order, again, just read this item with me, 3rd of September, passed an order deciding issues of maintainability and of enforcement petition in my favor. It was inter alia contended by R1, the opposite side, that the Arbitration Act is a self-contained code and the applications are not maintainable until we reach 49, which means that once your lordship reaches 49, he can dissipate. I hope I'm clear, Manas.
Yes.
Till the enforcement objections are decided, he can dissipate what he likes. It's an extraordinary proposition. It was held that the interim application in the present case substantively invoked provisions of Act akin to provisions could not be a mere technicality. Therefore, this order is in my favor, extends the interim order till 4th of October. A second time, unfortunately, the learned single judge, the division bench grants a stay. Now, just come to my note below. This will be simpler. First of all, the appeal to the division bench doesn't lie. Well, just come below to summary of arguments. Straight away to be easier.
Yes.
Now, just see, Manas. The learned single judge's orders are not appealable. I'll show the section in a minute. It's a foreign award under 44. Therefore, you can appeal only under Chapter 1, Part 2. 50 is the section. Lordship will note on the next page. It allows appeal only against orders refusing to refer the parties to arbitration under 45 or to order enforce a foreign award under 48. Learned single is there neither. I hope I'm clear, Manas.
Yes.
Just see 50 for a second, Manas. Your lordship doesn't mind. And the judgment is directly on point. Your lordship's Kandla.
We've got it here, yes.
All my three lords have it. It's on the screen. It's on the screen also. Not, your lordship knows this has that word only, all these.
Refusing to refer or refusing to enforce?
It's common, I will not say common, it is obvious that it is neither of the two categories. Your lordships in Kandla, in para 17 to 23, which is listed in my para B, have directly upheld this interpretation that we have filed the appeal under Commercial Codes Act. If Commercial Code Acts appeal are maintainable, then 50 become nugatory. I hope my lord is clear. Double I. Kandla is this only, that a special act, Arbitration Act, can't be nullified by general right of appeal under Section 13. Commercial Codes Act, Section 13.
Reading 13.
This view is still.
Only there is no everything problem. Unless 13, this 50 has
Now, but I want to just show the next 2 points to lordships. Section, Kandla, following Purus Lawson. 3 things directly in the teeth. Now let's just see the next point and I'll show what the learned division bench did in a minute. Let's turn to my notes.
except the provider to 13
Well, Arbitration Act can't be overridden. It's a non-obstant clause.
Commercial Code tells you the forum, but
whether an appeal lies or not is not decided by Commercial Code.
says the enforcement will go.
The Commercial Courts Act tells you the forum. It doesn't decide whether you can appeal or not. Whether you can appeal or not is decided by a substantive provision called 50 in a self-contained code, Arbitration Act, with one of the non-obstant clause. With a non-obstant clause. Yes. Whether in an arbitration matter you can appeal or not is only governed by this act, not by the Commercial Courts Act. Commercial Court is saying the forum must be the Commercial Court.
Yeah,
Notwithstanding anything contained in any other law, my lord has not got it.
yes.
Notwithstanding anything contained in any other law for the time being in force. So it specifies.
Yes.
It specifies. And it starts with non-obstant. Plus your lordship has a judgment directly on point. Now, it is mixed up with the Commercial Courts Act which provides a forum. Suppose Malus 50 gave you an appeal. You would go to a commercial court, no problem. You won't go to a non-commercial court. If did not give you appeal, you'll go to whichever is the commercial court available. Now, let's just see how the impugn order deals with it. This is very interesting. Yes. But I must tell you something startling on the merits in a minute, because all this appeal will not get me anything. What they are doing was today, by a clear default and an award of 1400 crores, they have to give me only information for me to start the process of strategic sale. They don't give me information. That's the stay which is operating against me.
They have to pay by 3rd October.
They have to pay by 3rd of October under the order, which by the division bench is now Malus state. Now come to the impugned order. Is this the way Malus with great respect to deal? Only the contentions of the other side are noted and it is said, I accept them.
Now, where do they deal with the maintainability of the appeal specifically?
Para 8. That's what I'm asking lordships to go to. Justice Padiwala has got 8. Justice Mishra has got 8.
Page?
Page is 7. PDF should be 34.
Para 8.
Para 8. Just 8 to 10. That's it. Actually, no decision. It's only a contention noting and then agreeing. Learned counsel for appellant, that is the other side, submitted that Kandla is a matter where, on facts pursuant to a proceeding in UK, an execution petition was filed in a district court in Gujarat, and thereafter the High Court transferred the execution petition to Gujarat High Court, after which the Gujarat High Court dismissed objections under 48 of ANC. Dismissal of objections under 48 is not appealable under 50, and Kandla is a case where what is expressly unavailable under 50 was thought to be filed by taking 13A route. It was also argued that Kandla is a case where 50 was clearly unavailable. At 50 will be available only if 48 objections had been allowed. Where do you get this from us? So 50 is available in 48, but an interim order is available under 50. Well, just kindly pause here. It means that 50 will lie when a final 48 is filed, passed, but will not lie then, but will lie when an interim order is passed. It also emphatically and respectfully submits that Kandla is not an authority for a case where an appeal is preferred, complaining that the impugned decision is without jurisdiction. It was reiterated that in Kandla what is barred by 50 was sought to be reintroduced, reinfused by way of 13. It was also submitted that Kandla is a case where all contentions only of 48, contradistinction on the hand, etc. without jurisdiction. Then Malas? No.
But they say in Paratin, in the light of narrative discussion thus far,
yes,
this CAD.
No, but just read 9 also, just 9.
Counts to say that this CAD is prima facie satisfied.
Yes.
That the appeals are maintainable, but there's only a record of prima facie satisfaction.
Not only that, it is not a record, Malas. It is a record of Mr. Sundaram's counterpart's contentions.
Yes.
Without any reasoning of the High Court.
Why is it without jurisdiction?
Malas, these are contentions.
Contention.
Now, Malas, before that, now. So, now let's see what the practical reality is.
In the proviso to 13(1)(a), there's a reference to section 37. But there's no reference to section 50.
The scenario deals with it in para 21. Malas.
I saw that, yes.
He deals with that precise point. He said there could be many reasons. But one thing is clear, the controlling authority is 50. And that's the right way to, otherwise the Lordship Malus will find that 50.
There is a little difference in terminology between section 37 and section 50. Because 37 and no others.
No others, correct.
50 doesn't use the expression.
But that is why it has been interpreted now. It has been interpreted now
by this
judgment. And Malus, this is not a fair way of dealing with this judgment in the DB. Now, one more para I forgot to mention. Para 19 is the only other para of the DB, which I should have mentioned, which deal with it. And then I want to show what the practical realities that your Lordship should know. I don't want to argue an abstract point of maintainability without your Lordship knowing what's happening on the ground. Come to para 19. of the same impugned order at page 18 or PDF page 45. Lordship has got that? To buttress the prima facie satisfaction, we also say that if same proceedings, albeit without jurisdiction in the light of explanation to 47 and 54, were in a district court, this court can be approached as a power to sue is available under 227. Whereas owing to the proceeding being before commercial division, it cannot be gainsaid that this CAD cannot be approached by way of an appeal. Well, when you have 50, you can't approach by 227s.
We told why you tell it now? Certainly. So what?
Have your Lordship seen this para? Well, is that para 18 of Kandla also addresses my Lord the Chief Justice's point in more detail. I've already read 2021, but this is more detail. May I read 18, Malas, for my lords? That's the query the Honorable Chief Justice put in my case compilation, page 15.
This distinction was dealt with in law.
Yes. One of the submissions made before this court is that in the identical submission of Sri Giri before us, 37 contains the expression and from no others, which is conspicuous by its absence in 50. This was answered by the court as follows. Para 60 and 61. Next page. It is also evident that part 1 and part 2 are quite separate and contain provisions that are independently in their respective fields. The opening words of 2, that is the definition clause in part 1, make it clear that meanings assigned to the terms and expressions defined in that section are for the purpose of that part alone. 4, which deals with waiver of right to object, is also specific to part 1. 5, dealing with extent of judicial intervention, is also specific to part 1. 7, that defines arbitration agreement is considerable detail, also confines to part 1 alone. 8, deals with the power of judicial authority to refer parties to arbitration where there is an arbitration agreement. This provision too is relatable to part 1 alone. Corresponding provisions are independently made in 45 and 54 of part 2. The other provisions in part 1 by their nature shall have no application insofar as the 2 chapters of part 2 are concerned. Once it is seen that part 1 and part 2 are quite different in their object and purpose and the respective schemes.
Just 2
minutes. No, this is the law part. 2 minutes more. The actual reality on the ground. Just 2 minutes more. Turn to my list of dates on the top of the note. This is important to know because maintainability gets nothing. It just he perpetuates an interim stay. Remember 3 facts. He has not challenged the award. The main enforcement is pending. It's an interim order for a strategic sale. Please come to item 2. This is 5/7/24. My Lord Justice Mishra has got it.
Yes.
My Lord Justice Pardiwala has got it. Number, this is very important because on the ground of this law, you are doing what on the ground? The SIC tribunal issued its final award on 5/7, awarding the petitioner, that is me, and other investors 1,400 crores.
Where are you reading this?
In my note of the
Item 3.
the second item.
Second item.
This is the reality which you should know.
Yes.
Not in the abstract. The SIAC arbitral tribunal is full hearing, detailed hearing, etc., awarding the petitioner and other investors 1,400 crores, out of which 661 is payable to me with interest of 5.33%, not a very high interest. Further, upon the respondent's failure to make the payments within 90 days, now this is 4 clauses. The petitioner and the other investors will be entitled to proceed towards a strategic sale as contemplated by Sasha to be complete within 6 months of the final award. Now just note above that, just above the list of dates, 1 para more, I'm sorry to trouble Malas, just 1 para above. D. The company and the promoters were required to ensure that a qualified IPO took place before the cutoff date of March. Clause 19 of Sasha says that if this was not contemplated, the investors became entitled to avail of an exit waterfall. The company failed to provide and it constituted a material breach. Now, Malas, the result of this is that they have to disclose information which I will then use for a strategic sale. The last board meeting was 3 days ago on 27th. In the board meeting, they refused to disclose, saying we have a division bench order. Not disclosure means that to buy such shares, this is a very well-known company. I am a very well-known company, the Azim Premji Group, which does in startups. They cannot go and look for buyers. Forget getting a buyer. Buyer will take a few weeks. They don't give me the information
Yes.
by this point.
My lord, three very
And one more thing,
important
one
facts
last thing. I'm
have
sorry,
been
one
glossed
thing.
over.
They are supposed to pay me
which changes
by
the-
3rd October,
Sorry.
an amount of
What?
661 crores.
My lord,
By
can
3rd
I,
October.
can I answer straight away?
How is the
There are
appeal
three,
maintained?
just one moment, my lord,
How is the appeal maintained?
I'm answering, my lord. My lord,
There are two judgments against you. One.
My lords, I'll
judgment of
explain
this,
why.
One in Kandla. And
I appreciate that,
Lawson.
but I'm explaining why and how. And some three important facts I need to point out to my lords. My lords will do. Statement made, we have not moved to set aside. The award was passed on 5/7/24. I have 90 days in Singapore to move to set aside, which is 5th October 24.
Move there.
A. 2. Page 4, both parties moved for correction of the award. The corrected award was passed on 22/8/24. These dates are important. My time, my lord, if I go on 22/8/24, I have 3 months to move to set aside the award. If I take the date as 5/10, I still have 3 months. My learned friend says hasn't complied, hasn't moved to set aside. Now, first question which arises, that's why the learned judge says, I am finding prima facie, page 23, he has posted it to 17/10/24 for hearing. This is not a final order. He's repeatedly says prima facie. Now, the second important point, my lord, I'm coming to the second point. My lords, kindly see what was done. Please take section 48.5. I'm just giving these important facts, and then I place my submission as to how it would be maintainable in this case. My lords, Arbitration Act, please see section 48.5. My first submission is the 3 months for setting aside the award has not expired. How do you move for execution? If, for example, under 34, I have 3 months, you cannot move for execution till the 3 months has passed. Now, how do they move for execution at all? Secondly, they ask for an order under section 48.3.
Kindly read that.
My lords, I'm saying firstly, their petition under 45, 47 was not even maintainable for 3 months. All right. They then file it. Then 48.3 says, if an application for setting aside or suspension of the award has been made, that is after I make my application to set aside, let me give them the full hilt. It's available even before I make it. Then, the competent authority referred to may, if it considers proper, adjourn the decision on the enforcement of the award, may also on the application of the party claiming enforcement of the award, order the other party to give suitable security. Here, 3 orders were passed. 1, of injunction against me, disposing. 2, to ensure that those properties were kept. 3rd was a mandatory order in implementation of the award, which cannot be passed under 48.3. Please see, my lords, and the only part, and that's the 3rd error of fact stated, the learned judge says it's only, I'm not dealing with the first 2 injunctions. They continue. This appeal is directed, please see page 6, paragraph 6. Page 6, paragraph 6. As already alluded to supra, page 6 of the order, though interim injunctions have been granted and the same are operating, for the present, interim direction alone is the epicenter. Malad, there were interim injunctions for protection of the assets passed. The third,
Those continue to order.
those continue.
Now, what is the operative order which has been passed?
Is number 3, which your lordships will find in the impugned order. It is found, my lords, at page, I'm just showing your lordship it's in the judgment itself. Page 13. Page 12. My lords, the cause of action even to demand a sale does not arise unless I don't pay in 90 days.
Now, where is the operative order? We make the following interim order. Interim
My lords, kindly see page 13.
Want to continue?
Page 13. This was the order of the single judge.
13, right?
Yes. Interim injunction restraining respondents 2 to 5 from transferring, selling, pledging, encumbering. That continues. That's not the subject matter. 2, interim injunction restraining respondents from any manner dealing with, encumbering, disposing, dissipating, creating third-party rights, alienating any immovable, movable property or assets. The 3rd is in implementation of the award. which cause of action arises only if I don't pay in 90 days. And 90 days is 22nd November. Only if I don't pay by then. Respondent 1
Now let's just see the operative order of the division bench.
of the division bench,
Page 19. Interim direction made by Viday 1 interim decision and extended.
yes, that is, my lords, the earlier, the learned single judge had passed 2 orders, both on the same direction. Interim direction, that is what I just read to my lord, number 3, and extended, has been extracted, reproduced. Supra, there shall be interim stay of this interim direction till the next listing. To put it differently, interim suspension of this interim direction till next listing, which is 17th October. As regards interim injunctions, Spray 1 and 2, the same will continue to
So what they have
operate.
basically done is that they have maintained the division bench,
Yes.
maintained the injunctions, but only stayed 12-3.
Which is an enforcement of the award by saying, my lord, what did the award say?
And your time for challenging the award is still.
It's still there. And lastly, I request your lordships to consider whether 136 should come in here when page 23, it's listed on 1710. And the learned judge has specifically said at page 11.
Dr. Singhi, I mean, there's no lack of clarity on what the division bench has done. They have maintained the injunctions on the alienation of assets. They have only stayed 12-3, which was really a disclosure to be made of data, etc. By the
Not more than disclosure, it was to facilitate the
Answer
sale.
straight away.
for the.
Can I
Facilitate the
answer
sale.
Now, second, the award today. I mean, can we say that the award is enforceable because they have 90 days time to file an appeal?
3 things. 1, 48.3 contemplates interim orders. It's
Of
a judicial-
security.
Can I just
Only
answer first?
security.
If an
48.3
application for the setting
48.3
aside, one
contemplates
second.
interim
If
orders.
an application for the setting aside or suspension of the award has been made to a competent authority referred to in clause E of 1, the court may, if it considers it proper, adjourn the decision on the enforcement of the award and may also
On the application of the party claiming enforcement,
but there is
order
no
the other party.
application for setting aside or suspension of the award.
I have time
Therefore, all
for
the
that.
more. If he doesn't file, all the more.
My lord,
Even if he had filed.
Yes,
Time.
yes,
Number
time
2,
to keep.
let me answer this. There is, the relevant date is 3rd of October, which is day after tomorrow, for payment.
My lords,
For payment.
both parties
1 minute,
went for
sir,
correction.
please.
The correction of the award was done.
3rd
22nd
October is the
August.
relevant date because the second correction is a ministerial inconsequential correction. Its time runs from 5th of July. This is misleading to pay. 5th July, he gets till 3rd October to pay. Now, today, let's come to the practical part.
My share value is depleting.
Today, Malas, if I don't do the strategic sale by 5th January, under the clause of the agreement, my right lapses. So what does he ask in 12.3? What is asked in 12.3? Justice of the case is what? Disclose information. He doesn't want me to disclose to me information on 12.3, which is all that I'm concerned about today before my lords, so that my right to sell before 5th January lapses. There is a direct clause, and that's the game he's playing. Now I
This is
ask
on
myself a
17th
question.
October.
What is invasive about my learned friend in which I am 50% shareholder? Just note this. Me and the investors are 50.1% shareholders. What prevents him from disclosing except a very clever game by filing a non-maintainable appeal and keeping it dragging and saying you have a negative injunction, but I'll not disclose. Negative injunction is against his selling the shares to third parties. I have to find, well, the clause, these foreign agreement lordship knows international arbitration clause is very clear, clause 19. If you don't do by 2016 cutoff date, I get an exit. Why can't he disclose?
My lords, the order is
Why can't he
for
disclose?
facilitation and implementation of the sale, and 17th October, the case is coming up.
It's an affirmative order. Disclose. That's what? I'm sorry. My apology.
China Brody, Chinese 12.
Sure, clear.
So we can, He will
Twist in
do
the
it.
tail. Well, 1 second.
Just 1 second.
Twist in the tail.
Sorry. What we will do is this. We'll issue notice in this appeal. We'll stay the operation of the, we'll stay further proceedings before the division bench in the appeal. Prima facie holding that it may not be maintainable. Now, he must have a bite at the cherry somewhere to challenge the conditions which have been imposed by the single judge. We'll leave open his remedy to move this court under 136, in which case we will consider the legality of the directions which have been issued by the single judge, because he has a case that, look, the award has not become enforceable today.
Absolutely.
Because the highest
One
3 months
addition.
go.
I understand.
Let him file a SLP.
No,
with us.
one addition.
My lords, I'll do that. But in the
I-
meantime, my lords, let them not take action because the order
no.
passed
Stay against
is
me,
to
my
facilitate sale.
Stay against me, myself.
Mr. Sundaram, you file an appeal which is not maintainable.
My lords, it was maintainable for one reason. I haven't come to that.
Can I say one twist in the tail?
But,
Mills?
my lord-
Your lordship should.
Dr. Singhvi, I'm being addressed. Allow me to answer, my lord.
12.3, which is only disclosure, is directed at the company R1. Company R1 doesn't file an appeal.
This is active.
In his first appeal by Mr. Sundaram, it doesn't challenge 12.3.
My lord-
12.3 is non-prejudicial, non-invasive. It asks for disclosure of information.
He never challenged the 12th direction.
I'm sorry, my lord.
Should he hurt me because he knows my
Did challenge it.
January? Why should
My
I
lord,
lordship hear?
my lord, my learned friend is wrong on
We
fact.
will only clarify that our having stayed the judgment of the division bench will not prevent recourse to 136 of the Constitution against the original order of the single judge.
My lords, can I make one more request?
See, nothing more. Single should operate then. Then I have to take my review. I want information.
My lords, I have one.
Just say issue notice.
Yes.
My lords, can I just say one more submission, please?
Agarwal.
There is one important.
Please don't give him any Mala's words because that will be
Manoj-
the High Court.
Or Mr. Sundaram, we'll give you another option. You withdraw your letters patent appeal and come here.
My lords, I'm saying, just give me 1 second. I want no more time. My lords, the award was, if 3 months after the award, it is not paid, then direction 3, the direction to sell takes over.
That's not
That
very-
3 months has not even
I
expired.
made the point. But therefore you
And-
withdraw. We'll give you one more option. You withdraw your letters patent appeal. I mean, not the letters patent appeal, the commercial appeal. And come here directly against the single judge's order. We'll see. We'll test the validity of the single judge's order.
Nothing else from a lordship.
Yeah.
My lords, the earlier order may be better because I'll only say this for one reason. Because I can't do that. My colleague cannot do that without his instructions. That's why, Your Lord.
Notice
But just keep this in mind.
But my lords, in the meantime, I only make one request.
that thing.
They say execute sale deeds. The order says execute sale deeds. That should not be done.
Alimony Council, waive service. Full stop. Next. Prima facie, the appeal before the division bench would appear to be barred by the provisions of Section 50 of the Arbitration and Conciliation Act 1996 as interpreted in one, Anla Export Corporation and another versus OCI Corporation, 2018-14 SEC 715, semicolon, and bracket 2, Day Lawson Limited versus Jindal Exports Limited, 2011, 8 SEC 333. Full stop. Next. The proceedings before the division bench, of the High Court of Madras, before the Madras High Court, in so and so appeal numbers lelo, shall accordingly remain stayed. Full stop. We also stay in consequence, the operation of the impugned order of the division bench shall remain stayed. Next. This will be without prejudice to the liberty available to the respondents.
Lordship will give me liberty, my lord.
Yeah,
Not with-
without prejudice, the liberty available to the respondents to challenge the order of the single judge in independent proceedings under Article 136 of the
My lords, I have one request. My learned friend says it's only to get information. The order reads as though they can execute sale deeds. My lord, let sale deeds not be executed.
that we
Lord,
file an
giving a lawyer
SLP.
friendly option.
File an SLP.
The lordship is giving a lawyer friendly option.
Moving to Sundaram appeared in law.
In Lawson.
Yes, I got
This
it.
is exactly what you had argued and it has been negative.
No, well, that stock
I was hoping I would get it reconsidered by 3 of my lords. Lawson was 2 of them.
Scalpel applies.
I was hoping to have it reconsidered.
Scalpel
because-
applies only to your
My lords,
lordships,
it
not to us.
actually Lawson appears because there's a clear distinction in the language of the 2 sections.
37.
I saw that.
And there is a
But Lawson
point there.
noticed it. It's,
No.
You know, they noticed the difference. And
I was hoping to have it reconsidered by three of your lordships, but anyway, my lord, that is not, can I make,
pro international
Can I-
arbitration view, we should be very careful.
my lords,
about
I would try,
some certainty in these matters.
my lords, I'm only worried, my lords, when I have that time to file the setting aside. Meantime, they implement the award and in fact enforce the award. I will do one thing, my lords, I'll have an SLP filed tomorrow itself and then seek liberty from your lords.